Welcome to another episode of Conduct Detrimental. Dan Lust, Mike Kravchenko, joining us. First time in a long time. Bryce Goodwin. What's up, boys?
How are you?
What's going on? Happy to be back. I feel, we haven't had, this is a new crew. It's the first time I'm on with Bryce at one time.
Definitely.
Yeah, so Bryce has been on a couple times. As I said pre-show, Bryce is looking very swole nowadays. I don't know what kind of students get very big during bar prep, but you found a way, Bryce. So kudos to you.
You have to find an outlet somehow to kind of relieve your brain from the gauntlet that is bar prep.
Well, good stuff. We are back. Again, I will take the blame here. I had a big arbitration trial-esque deal for the last week and a half. Exhibits, evidence, first week, and then you do witness prep. So, the last 2 weeks I've been MIA, and then I have people saying, "Why aren't you responding to my texts?" And mainly it's just my wife. But when I showed her, got 100. Listen, I know I'm not bragging about unread text, but let's just say conduct detrimental is very high on my list of priorities. And if I can't respond to my wife, I don't know how I block out time during trial prep to do an hour and change. Okay. But anyway, we're here. This is the important part. So while we were gone, I would say, we're always looking for the A-level story. And I think the one that caught my attention, caught the public's attention is in our world. It's in media. And that was the Jimmy Kimmel saga, which began and ended since we've been on. So I think that's probably the most important story from a legal perspective, from a First Amendment perspective. And again, we are an apolitical show. If you think I am siding one way, I'm not. I call it like I see it, and it is what it is. So we'll delicately, because I see Mike's face here. Mike's face looks like a face of terror that I'm going to say something bad. I am not. We're going to call it out. We're going to say what happened, and we're going to say what might happen as a result of it. Okay, and then beyond that, on the docket, we have a new Diego Pavia decision that Diego Pavia obviously setting out landmark decisions on the JUCO college level. Some new updates here. Bryce is going to cover that. We have Sauce Gardner, who I guess is setting precedent in what can't athletes say to fans, which I'm not sure was decided the correct way, but we'll figure that out. Mike, am I missing anything else, or is that everything?
No, that's all we got.
It's a great show. It's a fantastic show. Okay, so reminder, podcast sponsored by Themis Bar Review. Bryce, you just finished bar prep. What bar prep company did you use?
Themis, the one and only.
That's it. Mike, you look so happy. Do we have a promo code, Mike, that you want to say for us?
I mean, we definitely do. I feel like we've been hiding it from people for some weeks.
CD800, Mike. Don't delay. I have the show notes up. Clearly you don't. I have them, okay? You don't just make them for no reason. I have them ready, okay? CD800. I think you get $800 off. Just trust us. When you go out to check out, put in CD800, see what happens. Okay. Gentlemen, I think we're ready. I think we're ready. Okay, so I'll tell you from my perspective, and obviously, a week and change is now passed. So we've gone through and finished the Jimmy Kimmel saga. We'll see what happens on the other end if we have a lawsuit from the president, but we shall see. So again, I'm under the hood. I'm in the middle of prep. I'm dealing with witnesses. I'm up till 3 a.m. I'm not paying attention. Now, when I drive to and work, an hour and change. It's a terrible commute. It's not neither here nor there. And I see on one of my podcasts, Jimmy Kimmel fired. And I'm like, that's odd. I must have missed something very big if Jimmy Kimmel got fired. So, Bryce and Mike, I think it's fair to say that Mr. Kimmel's firing, and we'll say firing or indefinite suspension, which is not indefinite, it was just for a couple of days. Without saying anything political, I think it's safe to say that this requires some type of analysis of what he said and the First Amendment. Have I said anything controversial?
No, sir.
I think you're right on that.
Okay. I don't really listen to any late night show hosts. Listen, when you have kids and you're studying for the bar and being a law student, I'm not really watching late night shows. Jimmy Kimmel, I think, goes on at 11:30. So I'm not one that watches any late night shows. So again, this, that, and the other. Maybe I watch on demand. I don't really watch shows live. And, I'm sure like the three of us, a lot of clips come up. So, I don't know. I'm not sure many people are watching Jimmy Kimmel live nowadays. But from what I know about Jimmy Kimmel and a slew of late night hosts, let's just say not this era of late night hosts, the late night hosts for the last 20, 30 years. The president is fair game. You can make fun of the president whichever way you want, left, right, it doesn't matter. You can make fun of the president, and there were no issues. So the statement that seemed to get Jimmy Kimmel in hot water was a statement. Again, this is I'm not going to try to insert my own views in this. By the internet's take, seemed to be Jimmy Kimmel's perception that he was placing a political affiliation on the shooter. We don't need to get into all this other stuff, but obviously we're talking about the Charlie Kirk issue. So fast forward. Okay, Jimmy Kimmel is not taken off the air necessarily for that comment, but if you read the stories around it, he was taken off the air for refusing to apologize. Okay. So, and I think he was going to apologize, but it was being woven into a bigger kind of, take on different media. And obviously we've seen Jimmy Kimmel's return to the show. I think that's what he wanted to do. He wanted to call out the left and call out the right and make it a whole free speech issue. Okay. So, gentlemen, as we were sitting here before Jimmy Kimmel returned on Tuesday, we have Kimmel making a statement, which, half of it was making fun of Trump for, the renovations to the White House, half of which was making a statement on the shooter's political affiliation. I'm happy to give my take. If you guys want to stay clear with a 10-foot pole, I'm happy to jump on this. Did you guys have any sense, again, not whether what he said was true or false, whether what he said warranted him being taken off air at that point?
No, absolutely not. And especially, there's, like you said, there's a precedent in the comedy form of media that's kind of fair game. And I feel like it was pretty tame for in terms of a full-on political statement, if anything.
Mike, I would agree with you. Jimmy Kimmel's probably said worse. That's why it was a little alarming when it happened. And, we don't have to suss into exactly, again, what was said, what wasn't said. But Jimmy Kimmel's refusal to apologize, I thought, required some further examination. So, listen, in the grand scheme of things, right, whether you're on the left, whether you're on the right, I think you're fooling yourself if you would not say that at some point your party, and again, or if you're neither party, the left or the right, has taken some liberties in terms of censoring things that people might be allowed to say. Free speech is free speech. Certainly there are private forums that are regulated, public forums that are regulated. But we've gotten into a weird gray area, and I'm not going to say just in the Trump administration, probably a little bit beyond that during the Biden administration, at least. And I don't remember this being more such an issue before these past two presidencies, but here we are. So Kimmel comes back on air, and again, I've not watched. I don't think I've watched Jimmy Kimmel. I guess the show is Jimmy Kimmel Live, but I have not seen him like on the show live. I don't know, 10 years plus. So I watched it, and I watched what he had to say. And my wife is not really political. I'm not really the most political. And I don't really think watching Jimmy Kimmel is that political. But I understand that Jimmy Kimmel generally gets about a 1.2 in ratings, which I don't know is a pretty big number. His night of his return, he got like a 6.5 rating. So let's just say, 5 times the normal number of people are tuning in. And if we're trying to figure out where this next battle is, be it sports anchors, news anchors, comedians. Like I wouldn't necessarily think a comedian would get into hot waters, but here we are. Jimmy Kimmel's monologue, which again, you can have your thoughts on Jimmy Kimmel. I think he brought in the left, he brought in the right, and he brought in this concept that at the end of the day, what he was most taken aback by were the people that hated him on, we'll say the right, but that nonetheless appreciated his ability to speak freely. Bryce, do you have any thoughts on the law, kind of long term? And again, we're just flagging this. We sometimes we identify sports issues, but just bigger legal issues that could touch upon sports. But go ahead, Bryce.
Yeah, absolutely. I think the first thing that pops into my head when thinking about just the general concepts of free speech that this situation is highlighting. It's a case that I actually studied in law school in a special constitutional free speech class, and I'm sure it's a case with which a lot of law students and some constitutional attorneys are familiar. And it's the Johnson case that occurred in Texas, where we're talking about the burning of the United States flag. And I think, that was obviously something that for people who have a lot of national pride, that was something that they were that they disapproved of a lot. But the court in that case ultimately said, as a form of expression, that form of expression is protected by our Constitution. Everyone in the United States has the right to speak their minds, subject to a few exceptions that the Constitution outlines. But without that freedom of expression, then those ideals that the creators of our Constitution built the document upon would be fruitless. And so, I think that in the wider entertainment and sports landscape, especially modern day, where you see a lot of athletes and organizations speaking out over topics that can be divisive, it's just important to recognize that no matter the shifting nature of the landscape, the constitutional protections still exist. And they're there for a reason. And it's one of the things that makes our country so great, is that, ultimately we can come and there are different topics and people can disagree on those topics, but we can have conversation and dialogue. And, we can respect the fact that we have the freedom to make those comments. So, I think that that's just something important for us to remember, in terms of the legal sphere, when coming to react on situations like Jimmy Kimmel and a lot of future situations that are probably going to be of similar ilk and that will probably take place in the near future.
Well said. Well said. And listen, you guys got nervous. You said, let's lead with Jimmy Kimmel. I probably have some more colorful thoughts, but I'm not doing them here on the podcast because I don't want to get us all canceled. No, I don't know. Listen, at the end of the day, I don't think this is controversial. I think Jimmy Kimmel has said much, much, much worse, and the political climate is very tense. And, I didn't expect on my bingo card Jimmy Kimmel to be canceled for that. There was different people that said maybe even worse things. So, but I will say, and we're a podcast that speaks about defamation, and we'll cover Mike Sauce next. But, there is a line, and this is, again, if I get in trouble for this, I get in trouble for this. I'm not intended to be political, but there is a line of like whether what you say is true or not true, right? And I do, again, let's play it where it lies. I do get why Jimmy Kimmel was basically accused of putting a political affiliation on the shooter. That's what I think. Listen, I'm not an idiot. I listened to what he said. That seemed to be the joke. So there were people that said he said X, and the evidence seemed to reflect Y, whether it's true or not true, whether we have to check voting logs or not. I tuned in to hear if we were going to get that, just almost like a fact check. Like, hey, I said X, it turned out Y was true. And for better or worse, depending on which side you're on, Jimmy Kimmel didn't say that. He didn't give you the blanket, pure apology that I think ABC and Disney and the executives were looking for. So if you're on one side, you're pissed that he didn't say it. And if you're on the other side, it's kind of interesting he didn't say that, right? And again, not that we're going to get that deep into it, not that we're saying it should happen or shouldn't happen, but there have been threats by Trump and those on the right that Jimmy's statement didn't go far enough. There's been calls on the left for investigations about how the FCC and ABC allowed this to happen. So I'm not sensing the end of the saga, and we're not doing our job if we don't, in some way, shape, or form, provide our foundation for our thoughts. And to the extent there's a bigger issue, we will discuss it. There's a larger tie-in to the ESPN, ABC stuff with Disney, but we don't need to get it in here. Okay, Mike. That being said, defamation, truth, not truth. Logical assertions of fact versus opinion. Let's move over to your friend, Sauce, the boss, Gardner, Jets defensive back. What's going on with Mr. Sauce?
Yeah, Sauce Gardner. He's in the news again. I feel like he's been in the news a ton since winning Rookie of the Year and becoming the highest paid cornerback in the NFL. I bought his jersey right away. Like, yeah, he was my man. This is definitely an interesting and goes right along the lines that we were talking about on quote unquote freedom of speech and how things are taken, defamation. So Sauce this time was being sued by a New Jersey woman after a full year ago. They had an exchange in August of 2024 on Twitter, in which Sauce replied to the fans' joke, implying that she had an OnlyFans link. So what he had said, she replied to one of the tweets, and he had replied with, "I'm sure your husband wouldn't like it if I told him you DM'd me your OnlyFans link, would he?" Of course, that tweet was deleted, but it made some moves for sure, because later in the year, the woman ended up filing suit in Morris County, alleging defamation, like you had mentioned, intentional infliction of emotional distress, and other related accounts that actually were including Sauce, but also Barstool, basically saying that Barstool had continued and been a part of the situation or a part of the post because they had written an article about it and continued to promote Sauce's reply. So what the complaint alleged in it was that Sauce had knowingly and maliciously published a false factual statement that she had an OnlyFans account and had DM'd him an OnlyFans link. Only the two of them would actually know, and I guess Twitter. But the complaint says that it was untrue, widely viewed. I mean, it was millions of impressions, and then, of course, continued on Barstool for amplifying the claim with the article, and even ran a bikini photo alongside it. So Barstool definitely there had kind of amplified the situation, and it was causing harassment. People were reaching out to her account, a reputational injury. Her name is on there, and the emotional distress that goes along with all of that. So you had mentioned, Dan, I'm interested to hear your take as I go into a little bit of what actually happened and the result of all of this. But the court, at the end of the day, in early 2025, the defendants moved to dismiss it. Sauce and I really just Sauce in the situation, basically citing New Jersey's recent anti-slap protections from 2023, and argued that the posts were, in the sense of trolling, and it wasn't. It wasn't really it was a non-actionable, I guess, or failed to plead necessary fault. Excuse me. And so we were just talking most recently, the court dismissed the complaint. Why they tossed that, the public reporting and the filings that we got, point to the three things, really two things I'm going to talk about primarily that really carried the why they tossed it. First is I mentioned the anti-slap background. So New Jersey enacted anti-slap protections in 2023, as well as some related fee shifting procedures that actually ended up why he got attorney's fees at the end, and in $105,000. But beyond that, the courts basically can dismiss meritless public interest defamation lawsuits early and award the fees to the prevailing defendants. So Sauce and his attorneys had invoked that. The court dismissed, and the fees were pursued under that statute. So that's where we go there. One of the really interesting parts of this is the argument that took place, and that normally courts I would say treat short social media barbs, I guess, for lack of a better word, and rhetorical hyperbole things as, again, non-actionable opinion or not asserting provable facts. Sauce and his team used that. They were saying, hey, this is trolling. This is all part of, banter, sports banter, and going back and forth. This is the norm on Twitter. And, their response, even the woman's response, was, a part of the joke. It initially didn't seem to had taken it or had that distress. So it really is interesting how they utilize both that argument, and then really at the end of the day, why I think they tossed it was the anti-slap protections that they put in 2023, and I think it would definitely long term have I guess an impact, because the way that athletes and musicians and a lot of public figures interact with fans on
Well,
Twitter, especially Twitter, is in a
yeah,
trolling nature, I feel like. So
I'll
yeah,
jump
I'm
in.
curious,
Yeah,
Dan, to hear
I
your
read the headline
opinion on
originally,
the
and
outcome.
it said, Sauce Gardner gets $50K in attorney's fees against Fan in a lawsuit involving Fan and Barstool. Sorry, in a lawsuit, I guess, involving Sauce and Barstool. So, I don't know, that seemed to me, as I read it, okay, what kind of frivolous case was filed that 50,000 in attorney's fees were awarded, but how do we get to 50,000? Like it's a very big number in a case. Mike, what was it? Was it a pre-answer motion to dismiss? Do we know this?
Yeah, it is.
Yeah. So, Bryce, I'll give it to you at some point. I've shared my thoughts with you guys. The first thing, which maybe I'm the only one that thinks about this, $50,000 to spend on a pre-answer motion to dismiss. I don't know. That seems like a lot of money. And when attorney's fees are awarded, it's a two, like, I could put in whatever I want for attorney's fees. It's not that I'm going to get granted, but you have to show the reasonableness of your fees. So, 50,000 seems like, if it's just based on attorney's fees, actually the amount of hours billed and it seemed to be reasonable. This must have been some fucking hell of a pre-answer motion to dismiss. Must not have been a page limit on the pre-answer motion to dismiss. That is a very big number. You guys might tell me it's a precedential, case-setting, earth-shattering moment in the history of sports media, but that's a lot of money to spend on that. And it's a lot of money to spend on a case, to me, that, again, it didn't seem frivolous. And Mike, as you explain it, it doesn't seem frivolous. Put it this way. If my wife was in a fight with an athlete and the athlete with their giant platform said, not implied, well, I guess we can say perhaps joked, but said seemingly in an affirmative manner, you sent me your OnlyFans and does your husband know, blah, 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 and made that assertion. Certainly there's reputational harm. Certainly the thing is not true. So it's not on its face to be frivolous. It's not a matter of public interest that the world needs to know. So, your general parameters of anti-slap don't seem to be ringing true. I get it. At the end of the day, we don't have all the big details in the case. We don't have this. And I do view, Mike, and this is what we talk about, in my class or otherwise when we do like the stuff on civil cases. Anything you say can and will be used against you in court. If you, even just your use of an emoji, Mike, she put like crying, laughing emojis as a response?
Yeah, and the response that she had given was part of the banter. I mean, for sure, it was definitely not reflective of someone.
Right. The case law is essentially you have to make a factual assertion, and if the person that you were intending the joke to is responding with crying, laughing emojis, I mean, certainly you can just poll the audience, like how many people were laughing, how many people were saying, send it to me. Barstool clearly didn't think it was a joke, so clearly it was a mixed bag. But if the person who you were talking to said it's a crying, laughing emoji, that's a pretty good indication that she didn't think it was serious. And then, whatever the version of buyer's remorse or Twitter remorse, basically wanted to change her tune to cash in. So, I'm not sure we have the right result here reached, but again, we don't have all the facts. But it doesn't scream to me a frivolous case warranting of 50,000 in attorney's fees. Can you imagine being this woman getting into a fight with Sauce Gardner online for about whatever, getting basically quasi-told, telling the world you have a OnlyFans account, and people, Barstool on different sites putting you up in a bikini, only to then get hit with 50,000 in attorney's fees? It sounds like a bad day at the office.
I would definitely say so, but I think that's just another reason why everyone's got to delete Twitter nowadays. Just stay offline. Don't go at them.
Yeah, I mean, it's almost like you think about the bar. If you were to deem Twitter itself as like a contract, it's almost unconscionable the difference in bargaining power between an athlete as famous and as well known as Sauce Gardner, and as a normal person like the three of us, because obviously with the climate of sports Twitter nowadays, I don't necessarily know how ingrained you guys are on sports Twitter, but I'm pretty involved with the soccer Twitter side, especially with European fans, as my team Arsenal is constantly criticized and ridiculed and mocked by everyone, and this, that, and the third online. It's pretty difficult when something goes against you on that website to be able to come back from it. And so, I definitely agree with you, Dan. I don't think that, regardless of the facts of the case that we don't know and the merits of the arguments, I don't know if this case was sufficiently frivolous to warrant that amount of attorney's fees, especially considering the likelihood that this woman, who I believe I read was a young wife and mother, got absolutely torn to shreds on Twitter by fans and individuals who either thought the situation was funny or just wanted to defend Sauce Gardner. So I think that the result in this particular case is kind of it has an unfortunate consequence for interactions between fans and athletes on social media platforms, because now there's a precedent that's been set that regardless of the merits of a particular case that's speaking to an interaction, there can be drastic consequences for you as the fan. And so like we've been saying, it all ties into freedom of speech and the consequences of your speech. But yeah, must admit that the result in this one is surprising.
This is just an important thing, right? At the end of the day, anyone can sue anyone for anything, but there are ramifications to doing so. I have a client who shall remain nameless, but from time to time tells me about a case tells me about something that they want to sue on. And I said, listen, if I file that case as a lawyer, there's certain things that I should know are frivolous. You as a pro se, you might not know that, and a judge might go a little bit easier on you for not knowing that. But I certainly can't recommend that you do it. But if you or I is going to do it, and I don't think it's a real case, but you are still adamant that it should be filed, go ahead, you can file it. But to the extent here, and Mike, do we have any concept of the law firms involved? I know you have all the stuff ready.
Yeah, they're both represented by lawyers.
Yeah, at some point maybe you'll tell me who, but I don't need to do that on the air. But in any event, interesting nonetheless. And I guess, Mike, to your point, and Bryce, maybe we've set some precedent. Don't get into a fight with Sauce Gardner online. He's just as scary online as he is in between the lines on the field. Okay, cool. Let's move on. Third and final topic. We'll have some probably some what to watch for stuff, but let us see. Bryce, tell us about the latest with Diego Pavia and what has been, we'll say, an eventful landscape on the college law field. We'll probably bring our friend Sam Ehrlich back on in the next few weeks to do a roundup. But Bryce, tell us what's going on with Pavia. That seems to be the main case.
Sure thing. So, obviously Diego Pavia has been making news, like you said, on and off the field, dynamic quarterback for Vanderbilt, who seemingly backs up the talk he does off the field on the field. And so I think that has kind of led us a bit to where we are in the Sixth Circuit. But before we get into what's just currently transpired, I thought for our viewers who aren't so familiar, we just give a quick little background on what's going on. So basically, if you weren't already aware, Diego Pavia recently sued the NCAA by arguing that their eligibility rules were a violation of the Sherman Antitrust Act. And so specifically, he was arguing that, because he spent some time in junior college, that those years shouldn't count toward the 5-year rule and would thus allow him an extra year of eligibility to play for Vandy. And so obviously this case was originally filed in district court, and the district court, after going through an antitrust analysis, granted Pavia a preliminary injunction, which effectively, while that injunction was pending, allowed him to play in this season for Vanderbilt. And so that case that was in the district court has now gone up on appeal to the Sixth Circuit, and arguments were recently heard. I believe they were heard on the 16th of this month. And so, there were a couple of issues that were primarily at play in the appeal. One of the interesting issues, I think one of the beginning issues, concerned the mootness of potential validity of this preliminary injunction, because effectively, what the judges on appeal were wondering was whether, the outcome of this case has any practical significance, given the fact that Diego Pavia already has what he wanted by being able to play this season. And because he's already started playing, the judges were wondering, well, why even argue the merits of this case? And so, that ultimately sparked interesting discussion between the judges and the lawyers for both Pavia and the NCAA. But I think more interestingly, there was discussion on the question of the eligibility rules at issue and whether they were considered commercial for purposes of antitrust scrutiny, because obviously the determination as to whether those eligibility rules are commercial or not would obviously make a difference as to whether they'd fall under the strict regulatory purview of the NCAA or whether they'd be held subject to that Sherman Act. And specifically, the court was wondering whether the House settlement that recently was passed down made any difference as to whether these eligibility rules are commercial. And so, there obviously, because this was recently argued, the judges will render an opinion in the near future. But I think that the broader question here, because at least practically, since Pavia is playing, he got what he wanted. And so, the remedy for him is being able to play in his last year for Vandy, and he's doing that. But I think on an academic standpoint and on a legal standpoint, there's just another antitrust challenge to the regulatory authority of the NCAA. And it's made more prevalent given, the developments we have each day on name, image, and likeness, on, the consideration as to whether athletes are considered employees, and obviously the recently handed down House settlement, and subsequent financial agreements that, college athletic programs are laying down with their athletes. So a lot of interesting questions here, more antitrust struggles for the NCAA, and it'll be really interesting to see what the Sixth Circuit decides.
Bryce, that was a lot. I could tell you just fresh off of your bar prep because that was very, very well spoken. Now let's turn this to the football side of this. Let's break this part down, which you helped explain. Diego Pavia, including his junior college, how many years will he have played, including this year? And I'm talking about played, like actual, we'll say quasi full seasons.
So he's played 2 years at the JUCO level, played 2 years with New Mexico State, and he's currently in his second season with Vandy. So overall, he's played 6 years of football. At
some point, Bryce, there has to be a limit of how many years someone can play. I get it, right? Who's the NCAA to set limits on eligibility? But let's just use common sense. We have college football and we have pro football. What we're leaning into, which, again, I don't know, I hate to be the bearer of bad news, but college and pro are blending a little bit because we're having people, which, if we do want to check the archives, they said a good part of the NIL era might be instead of guys being, drafted in the 7th round and basically being forced to play, they'll stay another year if they're a junior, and they'll stay to be their senior year because they get to get paid. What I don't really think many anticipated is that we would just lose sight of just kind of common sense. College is 4 years. I get it. If there's a red shirt, I get it. If there's an injury, but the point is we have to set some limit somewhere on what it's supposed to be. Now, I get it. Pavia wants to say junior college doesn't count. If you ask an NFL scout and you're watching someone play at the junior college level and they're making X amount of starts, again, at the junior college level, it's not talking about high school ball. We're not talking about something else. We just have to use common sense at a point. And I'm not rooting against Diego Pavia. I am rooting for strict and very clear limits on what you can and can't do. And I'm also of the opinion that, we've certainly talked about this before in the show, but someone needs to be able to be the adult in the room, whether it's collective bargaining, whether it's, the NCAA setting a number and being firm to it. That's what they're trying to do, but you have different decisions being weighed and leveled across the country that are inconsistent. So I'm not ready to say that Diego Pavia isn't right to seek what he's seeking, but in terms of, 6 years of being at the start, a starting quarterback at the collegiate level, it's getting a little crazy. So like at some point, yes, I get it. Pavia is fighting, to play at Vandy for that first year. It's his fifth year. It wouldn't be the first time a guy has played 5 years, but to have 6 years as a starter at the collegiate level, we're starting to get to a point like, guys, there was a guy that played, I think he was in his 8th year at Miami last year, that tight end. Bryce, what was the guy's name?
That player, Dan, was Cam McCormick. He was a tight end.
So I don't know.
Miami,
it's getting
like
a little
said.
ridiculous. There has to be some limit on this. I get it that COVID kind of laxed everything with transfers, but sometimes rules help, limits help. So again, I'm not rooting against Diego Pavia, but I'm not so sure I'm going to like the precedent set if he wins, that the NCAA can't make that limit at all. And I'm a little bit nervous of what that landscape looks like in this blurring of college and pro, which is what it is, but there has to be some limit after which your eligibility is exhausted. And I sense that a win for Diego Pavia moves further into the realm of the abyss.
Dan, I know that you said that you hated to be the bearer of bad news, but I'm right there with you. I tend to agree with what you're saying. I think that for all the good that the NIL era has done in compensating players for the product that they generate on the field, we've created a muddy gray area between a professional and collegiate landscape. And there are just so many areas where within that broader gray area that we're just not sure what to do. I think that, like we talked about here, this battle for Diego Pavia's eligibility seems more like one of semantics than one of justice for him, especially because, and I may be mistaken on this, I saw a tweet from Pavia himself effectively shutting down any rumors that he was seeking an extra year of eligibility, saying that this year would be his last. So I think that this battle over eligibility is more semantic than it is practical. And, I think that like you mentioned, collective bargaining, Dan, and obviously for these players to be able to collectively bargain, they'd have to be considered employees, not students. And obviously the Johnson case in the Third Circuit muddies the water as to whether or not student athletes can be considered employees, given that economic realities test that, at least in my opinion, isn't necessarily workable when you consider the differences between all the divisions in the NCAA and the different sports and things of that nature. And, you have a lack of wide-scale regulation over NIL, so we're leaving it to the states to determine how their institutions can operate under the NIL framework, and all these different things that, leave us at odds and kind of questioning where we go from here. And I think that it doesn't help the players, it doesn't help the institutions, and it doesn't help people trying to be involved in this new era of collegiate sports. And I think that imposing guidelines and restrictions, while they may be unpopular to people who are constantly seeking more eligibility to try and capitalize on NIL opportunities, it just muddies the water even further. And the longer we go without any form of guidelines and boundaries, I think the more confused we're all going to be. So yeah, I think it'll be interesting to see what the Sixth Circuit says on this. At least based off the questioning, I wouldn't be shocked if they ruled in Pavia's favor, but especially considering the current precedent that we have amongst appellate courts ruling in favor of college athletes and against the NCAA. But, the implications of that could make things more confusing and leave us right back here again.
So, Bryce, you and I are generally on the same page. We'll see if Pavia wins his case. We'll see what comes of it. We've been joined on the podcast by my youngest daughter, Sloan. Do you want to say hi? She said hi. That was her saying hi. You want to say hi one more time? Yeah, she said hi. Okay, it's getting to be about that hour where I get yelled at, taking too long. No, this is a day in the life. Let's do a what to watch for. I have one at the end. Mike, I'm looking at you. You look like you're ready to go. Tell me your what to watch for, and then Bryce, I'll clean up. We'll call this a day.
Yeah, I think it's actually a perfect one to watch from the conversation we were just having. The NCAA, on top of, we're talking about eligibility, there's a gentleman that played professional basketball that is going to play Division I basketball at Santa Clara this season. There's a player, Terry Darlin, that had played in the NBA G League Ignite. He was one of those players and played for, I believe, 2 years. Obviously, the program had shut down for the Ignite development program, but he played for other G League teams during the 2024-25 season. So, this is a precedent here. We talk about a lot of precedents and what the NCAA is allowing and what they're not allowing. So, it's real interesting because generally in the past, if you played any sort of professional sport, you were not eligible to come back, especially playing in the NBA. Obviously, it's not the full NBA; it's their G League, but it's still an affiliate. It's still their system. So, it's really interesting though. But it aligns with their the recent thing for international players who have played professionally overseas before entering college. That they've relaxed their rules for them. Since the NIL era. This is the new NIL era. So. Yeah, this guy, Terry Darlin, is going to go play Division I basketball at Santa Clara after playing professional basketball in the G League, and with hopes to eventually get drafted because this is his last chance. He's entered and withdrawn from the NBA draft twice, and you get a third quote unquote test the water one more time before losing your NCAA eligibility. So yeah, I think that's something to definitely watch for, to see if that's a pattern that begins, and then B, what's allowed really, and see if he's, I guess, allowed to continue this and play a full 4 years, because age wise, it's definitely going to be a big deal. I think this whole season, this is going to be a big highlighted story, especially if he performs at an elite level.
Yeah, that's an interesting one, Mike. I think that I can say the same thing or a similar thing. Actually, I know that there's currently a player, a soccer player for Ohio State's program that actually played for Newcastle United, and I believe appeared in a Premier League game and possibly a Champions League game. So. Now, likely this player, I don't believe, was on a professional contract at the time because he was a youngster, and the common practice is that younger players are likely on academy contracts, so there's likely not any impermissible NCAA violations there. But kind of interesting parallel when you consider players who have played in professional environments coming into college. I think a big story to watch for me. It's also related to college athletics, but with respect to international athletes. And I think that we're starting to get in this era of confusion and muddy waters. We're going to get a little bit more clarity, possibly with respect to whether international athletes can take advantage of their own NIL. Because just recently, there was a ruling in federal court over a particular collegiate basketball player for Arizona State's women's basketball team that are involving that player, where the federal court blocked the NCAA's attempt to categorically bar international student athletes from being able to seek applications for professional visas. And why that's important is that obviously in current day and age, international student athletes are usually at American institutions on F1 student visas, which prevent them from earning compensation while they're studying. But the professional counterpart to this visa would obviously allow for these international student athletes to be compensated for their name, image, and likeness, so long as they meet a particular definition, which it, based on all likelihoods, considering the nature and high profile of a lot of these international student athletes, could possibly be met. And so this situation is obviously still brewing. It's ongoing within the court system, but I think that it's a battle that hasn't really been spoken about a lot in the NIL discussion, because international athletes, at least at the higher levels of college athletics, aren't necessarily at the center of the spotlight, absent players like Zach Edey. But I think international athletes have contributed to the product that they generate for their organizations just as much as domestic athletes. I mean, speaking from personal experience, playing Division II college soccer, the vast majority of my teammates were internationals, and without them, the school would not have attained the reputation that we had as a soccer school without him. And so, I think that it is certainly a step in the right direction for allowing these international student athletes to be compensated for the work that they do. And I know that this is an ongoing fight that a lot of very talented and well-respected sports immigration attorneys are currently pursuing. So that's definitely my one to watch. And I think it's going to be something that we're going to get a resolution about, hopefully in the near future.
Okay, so I'll keep this very brief. I have kids screaming. I try to record from my office for this exact reason. This is not one of those days. So I'll just say this. I have one what to watch for, one bet. I have a lovely client. Shout out to Anthony Wasio over at Planet Euphoria, who got the hookup for Ryder Cup tickets. I will be there on Sunday. USA, minus 165. That's it. You're going to say, Dan, why are you picking a minus bet? Because this is America. Go USA. Okay, signing off. Thank you for everyone here at Conduct Detrimental. We will see you next time on another lovely episode of the Sports Law Podcast. Conduct Detrimental.